testing.
Yep. And all the others should be muted, even if they're muted.
Okay, I'll call this meeting to order. The clock shows 1 o'clock. This is a this is a public hearing for the Special Magistrate of Code Enforcement for the City of Newberry, Florida. It is 1 o'clock, and we will start this meeting with the Pledge of Allegiance, if y'all would join me. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, we are here for, as I said, for public hearings for code enforcement cases for the City of Newberry, Florida. The format of these hearings, it will be that I will take the cases on a case-by-case basis. I will take testimony and evidence presented by the code enforcement officer for the city. I will, if there is any of the owners or other interested parties present, I will hear testimony and take evidence from those persons. And based on those presentations, I will determine if there is a violation of the code that has been cited. Then, based on a determination of violation, if I do determine that there is a violation, I will determine what remedies might be ordered based on that, which may include the curing of the violation, which may include a recommendation to the City Commission to cure and take steps to cure the violation, which may include the imposition of a fine. So that's how the each individual hearing will occur. I do note on the agenda that the next item is approval of minutes, and I think that's really that would kind of be on the agenda if we had a board that was approving the minutes. I think we've discussed that my thoughts on that would be that that if the minutes are presented to me following the meeting, I'll just approve those on my own. I don't know that that really needs to be a part of the agenda. So do we have any remarks from city staff or attorneys present?
Good afternoon, Your Honor. No remarks other than just to let you know that we have 4 cases on the agenda that are new cases and then 1 reduction hearing.
Okay. All right. Do we have anybody here present on behalf of any of the landowners that have been cited?
Yes.
Yes. And
my name is James Long.
okay.
Representing Reeb Incorporated.
Okay, which would be case number
5.
which would be the 5th case today, which would be 2018-002.
Yes, sir.
Okay, and anyone else? Okay. So I'd like to propose, if it's okay with our code enforcement officer, to move that case first to accommodate the people present.
That would be fine.
Okay. So I think now we would want to swear in any proposed, anybody that intends to testify today. And let me wait just a second here.
Sorry, late.
Okay. Sir, are you here on one of the cases today?
I reckon so. I really don't, I ain't got no papers. I
Okay.
just got a little thing stuck in my yard.
Right.
There's an agenda there and a sign-in. But if your name and address would probably help us identify which case.
Your Honor, I believe that's Mr. Yan, who is the first case on the agenda.
Okay.
We can take them in any order that you please.
Right. Let me find out who all I have here.
You go by my house this morning?
Okay, sir, your name is?
Mine?
Yes.
Wade.
Last name?
Wade. Yon, last name.
Yan.
Yes, sir.
Okay, Mr. Yan, you appear to be here probably on case,
One.
our first case today, which is 2018-12. And ma'am, you are?
Deborah Stevens,
Okay.
418 Northwest Route 244.
It's just,
Case 4. Faith, Hope, and Charity?
Yes.
Okay, and sir, you are?
yes.
To
John
be-
McNeil Jr., I'm
Same
the I'm the resident.
So y'all are together on the fourth
Yes,
case that I'll be
ma'am.
taking today? Okay.
I mean, yes, sir.
Okay, I was just saying, we were entering in to the portion of these hearings where we swear in any possible witnesses that will be given testimony, and I would assume that's what y'all are here for. So if the four of you would please stand up, raise your right hand, Mr. Code Enforcement Officer, and Madam
Okay.
Clerk, if you'll administer the oath.
Thank you. Do you swear or affirm that the testimony you are about to give in this case today is the truth and the whole truth? And for those of you who are not city staff, can you please state your name and which case you're representing? Start with you.
Deborah Stevens, case 4.
John McNeil, case 4. I don't, what was my case? Wade, John, 1, case 1.
James Lemoyne, case number 5.
Okay, before the three of you entered, we had already discussed how we were going to proceed, and the gentleman that is here for case 5 was here first, and I'd already announced that I was going to move ahead with that case, so let's do that. This particular case, I'm understanding, is a request for reduction of fine that had previously been ordered in that case. So I want to read a little statement here before we get into the case specifics. The decision to grant or deny the request for reduction of a fine is solely within the discretion of the special magistrate. In making this decision, I, as the magistrate, may consider recommendations from the Code Enforcement Office. We would ask you that you state precisely what you're requesting and why you believe that your request is to be granted. You may present any information that is relevant to your request. The only purpose of this hearing today is to consider a reduction of fine, rescission of a lien if one had been placed. This is not an opportunity to discuss the original finding of a violation that's already been done. So we're not concerned about those original proceedings, and I have no authority to revisit my determination that there was a violation in the beginning. So with that, we will proceed. Mr. Code Enforcement Officer, you want to go first, or you want me to allow him to go? Okay. Okay, I will hear from you.
Reed Incorporated purchased the property in case number 5 after the violation And we have gone out, completed the work, cleaned up the property, and we paid the administration fine. And we would like to petition the court for a reduction to 10% of the fine if possible.
Okay, and specifically asking for a reduction to,
A reduction to the original fine of, I believe it was $4,900. It was 47, excuse me.
and so you're requesting a reduction of the $4,700 calculated fine to $470?
Yes, Your
Did
Honor.
you say 10%?
Yes, Your Honor.
Okay. When was my, and I don't have all that with me, when was the original order determining the violation? And maybe I need to talk to the code enforcement officer here.
Do you remember the original?
Yeah, I'll go through all that.
Okay, I'll hear from the code enforcement
Okay,
officer, and if I
absolutely.
need anything,
Absolutely.
I'll come back to you, and I'll give you another opportunity before we finalize.
Your Honor, Rick Wolf, Code Enforcement Officer with City of Newberry. The original hearing was in June, and your order went out on June the 15th, and it was for $50 a day for each day that the violation continued to exist.
And did that commenced not on June 15th, and I gave them a certain number of days?
Correct. And the number of days that occurred was 94 days, and therein lies the amount of $4,700, plus the $120 that was for the administrative prosecution cost, and that has already been paid by the applicant,
Okay.
by the respondent.
Okay.
As far as the city's recommendation goes, you may recall that in case 2018-02, respondents were Lundy and Murray, and it should be noted that the original respondents, Alfred Lundy and May Murray, were determined to be deceased at the time of the hearing, and that this property was essentially abandoned. Taxes hadn't been paid for close to 10 years, I believe, and the property was sold by the Alachua County tax collector at a tax deed sale on August the 7th, 2018 to Kirk P. Reeb, who with the knowledge, had the knowledge that there was an outstanding code violation and fine running with the property, as well as the outstanding prosecution costs. The new owner of the property took action to bring this into compliance for the code violation for hazardous lands within a reasonable amount of time. And the fine that was determined through the Special Magistrate's order had accumulated for 94 days at a cost of $4,700 before compliance was achieved. The current respondent, Mr. Reeb, has paid the administrative cost and has requested a reduction in the fine. The Code Enforcement Office recommends that this request be honored to reduce the cost of the fine to 10% of the original $4,700, which would now be $470 if paid within 30 days, and to release the lien. If the fine is not paid within 30 days, it should revert back to the original amount of $4,700. I know we're going out of order here, but I would like to show you just a couple photographs of this. So this was the property back prior to June. It was just totally over-vegetated. Property had been used for dumping of trash and debris. And you see a tire there in the picture. And it was just totally unkept. And of course, the former owners were deceased. Once Mr. Reeb took hold of the property after the tax sale, they completely cleaned the property, removed all the debris, and then also grassed the property, so it's now in a compliant state, and no more hazardous materials or hazardous lands.
Okay, so the your recommendation is to grant the request to reduce the fine to 10% of the,
Correct, to
what the
$470.
fine would be. How many hearings have I had on this? Just the one in June?
That's correct.
So it did not come back for a non-compliance hearing after that point, right?
That's correct.
Does anyone on staff know how much I charged relating to this case?
$120.
No, no. I separate my charge that I charged to the city for the case.
Oh.
And the June was the first round of hearings that we had.
I'm not sure it was broken down by case.
It is on his invoice.
Okay, and I think I do remember, I did look at this, and I think I do remember on that first round of cases, I charged $500 for this case.
That's what I thought.
So, so my thought is, we've already recovered the hard cost of $120 that were associated with this, and 500 is really close to what y'all are recommending, so I think I'm going to agree to release. Do you have any more comment that you would like to make?
No.
Okay. I think I'm thinking that I will reduce the fine from $4,700 to $500, which would let the city recoup what they paid me regarding that hearing. So that would be, I think, what my order will reflect. Okay. And okay, I just want to make sure now the property is now owned in the corporate name. Is that right?
Well, it's under Kirk E. Reed.
So it's not a corporate name. It is under your individual
It's
name.
under the owner's name.
Okay, very good. Okay.
Oh,
Okay. So let's move along now to case number 2018-012, which is the property in the name of Rosetta Yon Ayers. Yon? Okay,
That's what they made.
okay. Okay, Mr. Code Enforcement Officer, you may proceed.
Good afternoon again, Your Honor. Again, I'm Rick Wolf, Code Enforcement Officer for the City of Newberry, and my credentials are on file with the clerk. In case CE 2018-012, the respondent is Rosetta Yon Ayers, and the photographs that I'm about to show accurately represent the violation as seen, as was taken by me on the dates shown on the photographs, and is an accurate representation. On July 2nd, the City of Newberry, while on patrol, I observed a single-family mobile home lot with unlicensed and inoperable vehicles parked in the yard and junk and debris, including trash cans and auto parts. This was located at 501 Northwest 257th Street on tax parcel 0235600100. The property was inspected on July 2nd, 2018, and was found to be in the incorporated city limits of the City of Newberry and in violation of city ordinances, specifically Chapter 94, Article 5, Section 94-124 for wrecked or non-operating vehicles on private property, and for Appendix B of the Land Development Regulations for minimum housing for sanitation requirements, as it relates to trash and debris and rubbish in the yard. The property is zoned single-family mobile home, RSF MH2, and is approximately on 0.23 acres in size. The property is currently not homesteaded. A notice of violation number 2018-0704 was mailed by certified mail on July 11th to the owner of record as recorded in the tax collector's office, and it was received by signed by Wade Yon on July 23rd, 2018. The notice of hearing was achieved by posting on November 27th, 2018. In that notice of violation, the respondent was given till August 8th to correct the original violation by completing one or more of the following actions. To repair and provide current license tags for inoperable vehicles or removed from property, and to clean up the cans, auto parts, junk, and debris and remove them from the property. Several extensions were granted to the respondent, and as a result of my inspections, July 2nd, October 30th, November 6th, November 15th, and November 27th, it was determined that gradually the property was brought into compliance, and on December 18th, it was considered to be in violation, but now in full compliance. I'd like to show you some photographs of the site. This is a car on
That's why the
jacks are raised. You can see two other cars in the background on the left of the right picture. Here's a truck that was unserviceable, flat tires on the property. And here's some of the junk and debris that was in the front yard, cans. These photographs here were taken on October 30th. This is another vehicle that wheels off, and you can see the truck still in the property on November 6th. Again, cans strewn throughout the front yard. This picture was taken on November 15th. The truck is now removed. Here was another vehicle there with a flat tire. And on November 27th was when we posted the notice of hearing for the property. And in addition, we did post at City Hall as required by state statute. And this is the photograph taken on yesterday. As you can see, the photo on the left, the truck is gone. The photo on the right, all the trash and debris in the yard has been cleaned up. There are no more vehicles on the property. So as a result, we recommend a finding of in violation but now in compliance for the respondents Rosetta Yawn Ayers for both Chapter 94 wrecked or inoperable vehicles and care of premises. With that corrective action stated in the original notice of violation, we are recommending no fine, and further that the county recover no prosecution cost at this time since it's come into compliance prior to hearing.
Okay, so you're recommending no fine and no cost to be assessed.
That's correct.
Okay.
We would like to just have you reiterate that that it is a violation and it has come to compliance. So if this occurs again, a violation as a repeat violation, then the fine would begin right at the start of the observation.
Okay.
Thank you.
I work on cars for a living.
Mr. John, step up if you would,
I work
please.
on cars for a living.
Yes, sir.
That's the law. 72 hours, a car can sit in your yard without a tag on it. Because where I live at, people steals around there. And if he goes by my house right now, none of that in my front yard right now. All of it's gone.
Right.
But it's in the backyard, but it's neat. But now, he's telling me I can't even park my lawnmower up front. My riding lawnmower. That's wrong. Because in the
Well,
backyard,
I
that's
don't,
silly.
I'm not, that issue's not in front of me.
Yeah.
If
I mean, there's more, there's a house, 3 houses. If I got pictures of the house right beside mine.
Yes, sir. Okay, let me,
But it's like he's picking on me.
well,
I've been there all my life.
not
working.
in front of, here's what's not in front of me,
Yes,
okay,
sir.
today.
So how can I bring that?
Nothing about a lawnmower is in front of
Okay.
me. Nothing about a car less than 72 hours is in front of me at
Oh.
this point in time. So if that happened, if you were cited based on that at some time in the future and think you have a valid defense to
Yeah.
that, then
Yeah, I
then I
can.
would hear that.
Okay.
But not today.
cool.
I'm not, I have no power to proactively
Well,
tell the code enforcement officer what
Right.
he can and cannot do.
Yes, sir. Yeah.
He brings it and then and then I decide.
I mean, I just can't understand even how he told me on my fence line, I had, old grapevines and sticky thorns, This is my fence line. He made me cut them down.
Okay, well,
When you look beside my house, it's the same way, really.
I understand, and maybe he'll get to that as another property at another point in time, but that's
drives by it
not,
every day.
that's irrelevant to
Yes,
this
sir.
today. What I think is relevant today is I've heard testimony
Yeah,
from the
he-
code enforcement officer that you were in violation. I
Yeah.
think you admit
Yep.
to some of the violation.
sir.
And that you're now in compliance.
Yeah.
He's recommending that I recognize that there was a violation that has now been corrected. And while I probably could impose some monetary fine and/or cost, his recommendation is that that there be no fine or cost ordered to be paid. So that's where I'm at today. And and I've heard nothing from you that indicates any change to that. Not that I would,
Right,
I
I
could
got
do
you.
anything
Yes, sir.
different.
Yes,
So,
sir.
okay, so I think based on the testimony that I've heard, no contrary testimony from the owner. And let me make sure I'm clear about this. Now, we're showing the title to be in,
The Rosetta, it's Rosetta Long Harris.
Rosetta
Her real name is Rosetta Long Yarn Harris.
okay.
It's
And
used to be
you,
a complex.
and Rosetta has
Yes,
passed?
has passed, yes, sir.
Okay.
And
And
it's
you,
still in her name. Only reason that is 'cause I don't want my name.
what is your relationship?
She's my mom.
She was your mom?
Yes, sir.
Okay. Are there any other co-owners
No,
of this
just-
property? It would just be
just me.
you?
Yep.
So you're in control of the property and you're living at the property? Okay.
Yeah.
Right, so,
Been there all my life.
my determination, okay, thank you, that's all I need. My determination is I am going to follow the recommendation of the code enforcement officer. I am going to find that there was a violation on this property. I'm going to find that the violation as of today has been cured, and there's no longer a violation on the property. And I'm going to impose zero cost and zero fine relating to this violation. Any further business on this case? Okay. Okay.
Can I make one comment?
Sure.
You were correct on case 5. You billed $500 to the city for your coverage of that case. I got the image.
Okay, so let's move now to case number 2018 dash, wait a minute. What do we have here?
015.
Okay, let's move forward. This would be 015 we want to move to?
I can go ahead and leave now.
Yes, sir, you can be excused.
Oh, yeah.
Pay this fine, go ahead and pay my fine to.
You can pay for that. You can pay it in there, and yep, I'll if they need anything, text me.
We'll do it. Thank you so much.
Okay, so our other folks here are for case number 015, is that right?
Yes, sir.
Okay, so let's move to case 2018-015. I'm showing the respondents in that case to be Faith Hope and Charity Deliverance Center, Eliza Bell Tate as president. Mr. Wolf, you may proceed.
Your Honor, again, Rick Wolf, City of Newberry Code Enforcement Officer, and my credentials are on file with the clerk. In case CE 2018-015, the respondent is Faith, Hope, and Charity Deliverance Center, Inc. The photographs that I am going to present into evidence do accurately represent the violation as seen and were taken by me on the dates as indicated on the photographs. On the 18th day of September 2018, while on patrol, I observed a single-family mobile home that was containing unlicensed and inoperable vehicles parked in the yard with junk and debris, including trash, cans, containers, located at 418 Northwest 245th Street on tax parcel 01917-013-000. The property was inspected by me on September 18th and was found to be within the incorporated city limits of the city of Newberry and in violation of city ordinances for Chapter 94, Article 5, Section 94-124 for wrecked or inoperable vehicles on the property, and for Appendix B for the zoning regulations, Section 4.2, parking and storage of certain vehicles, and for Appendix B, Section 9.24, sanitation requirements for care of premises. The property had unlicensed and inoperable vehicles parked in the yard, and there was trash, cans, and containers in the yard as well. The property is zoned single-family mobile home, RSF MH2, and is approximately 0.23 acres in size. The property is not homesteaded, and the notice of violation was issued 2018-09-012 by certified mail on October 23rd. The owner of record, it was sent to and signed by Pratt Tate on October 26, 2018. The notice of hearing was achieved on November 27th, 2018 by posting and also by certified mail on November 28th, 2018, signed by Nikki K. Brooks. So the service was both by certified mail and posting. Here are some photographs of the property. It's a single-family mobile home. In the background, to the left of the mobile home is a green Suburban, and this red vehicle was also kind of straddling the two property lines. Property was posted on November 27th. This trailer here shows some of the containers that were in the backyard and tires and sundry items which were in the process of being cleaned up, and the two vehicles on the adjacent property. There's the Suburban on the right photograph that was inoperable. So that was the date we posted the property on November 27th and also posted at City Hall. Here's a photograph taken yesterday. As you can see, all the vehicles are gone. The containers in the trailer is gone, and they've even started washing or pressure cleaning the trailer. So it was in violation, but now in compliance. So for this notice of violation, the respondents were given until November 20th to correct the violation and complete one of the following actions by repairing and providing current tags and licenses to the vehicles or removing them from the property, and removing the containers, auto parts, junk, and debris, and cleanup. They didn't meet that November 20th deadline, and that's why it was agended, but they have come in compliance now, so they were in violation as of November 20th, but as of December 18th, they are in compliance. So we want a finding of in violation but now in compliance for the respondents' Faith, Hope, and Charity Deliverance Center, Inc., for the Chapter 94 wrecked and inoperable vehicles and the sanitation requirements for care of premises. We also recommend that corrective action stated in the original notice of violation has been taken and compliance achieved, so no fine, and further that the county recover zero prosecution cost at this time.
Or the city. Or the city. The county or the city. Right?
Force a habit. That
Okay.
concludes my
All
comments.
right. Ma'am, are you here on this case?
Yes.
And what was your name?
Deborah Stevens, the administrative secretary.
Okay. Right. I can hear from you, but you've heard the recommendation. So on behalf of the corporation, is that acceptable?
Yes, sir.
Okay. Then I will follow the recommendation, I think, of the, I will follow the recommendation of the code enforcement officer. I will find that there was a violation, that as of the date of this hearing today, that violation has been cured, and I will impose no cost and no fine on the owner. Anything more on case number 2018-015? Okay.
May we be excused?
Yes,
Thank you.
unless you want to hear about 013 and 014. Okay, did we have another gentleman here? No. Okay. So, thought we had another gentleman step in. Okay, so then we will proceed with 2018-013, Mr. Wolf.
Your Honor, again, Rick Wolf, City of Newberry Code Enforcement Officer. In case CE 2018-013, the respondent was Prime Medical Group LLC. And again, the photographs that I'm about to show accurately represent the violation as seen and were taken on the dates indicated on the photograph. On September 18th, 2018, the City of Newberry received a citizen complaint about a dilapidated fence creating a hazard located at 25156 Northwest First Avenue on tax parcel 02127-001-000. The property was inspected by me on the 18th of September 2018 and found to be within the incorporated city limits of the City of Newberry and in violation of City Code of Ordinances. Essentially for two sections, Section 14-334, which involves creating, keeping, maintaining, or allowing the existence of a dangerous building or hazardous land to be unlawful, and also relating to minimum housing regulations for not maintaining the property. The chain link fencing on the south side of the property and the wooden fencing on the west side of the property had become so dilapidated, decayed, and broken to the extent that it was unsafe and unkept. The structure was posing a hazard to health. As far as the photographs are concerned, this was back on September 18th. At that time, the property was also overgrown. You can see the vegetation was higher than the fence, the chain link fence, and there was some of the support poles of the fence were actually hanging out into the sidewalk, and there was the real hazard that a bicyclist or some pedestrian could have gotten injured by running into that pipe. Again, it was in pretty much an unkept state. We did contact the property owner by phone, and they did come in and first of all mowed the property, but didn't deal with the fence, and that's when we sent the notice of violation. This is the fence to the border of 252nd Street, and you can see there's many holes in it, and it was in a very dilapidated condition. This was the chain link fence that went along the south side of the property along Northwest First Avenue. Again, on October 2nd, no changes at that time. And then on November 14th, they started removing the wood from the fence, so just the fence poles were remaining, but the chain link fence had not been repaired. On November 27th, we posted the property as to the notice of hearing. And there you see the posting on the property, and we posted City Hall. And on December 11th, 2018, the entire wooden fence and the entire chain link fence was removed from the property, bringing the property into compliance. Again, this case didn't meet their 30-day requirement or compliance within the designated time that we thought was reasonable time to come and correct the violation. but they did come into compliance prior to the hearing. As a result of our inspections on September 18th, November 14th, and December 11th, we find that this violation had occurred, so they are in violation, but now in compliance for both the hazardous lands and the property maintenance issues. Your Honor, we recommend that we find the violator in violation but now in compliance, and corrective action stated in the original notice of violation has been taken and achieved, so no fine, and we further recommend that the city recover the prosecution cost of $0. And I'd be happy to answer any questions.
I don't have any questions. So with no other persons appearing, I will follow the recommendation of the city to find a violation, that violation has been cured effective December 18th of 2018, and I will impose no fine and no cost. Anything further regarding case 13?
Yes, sir.
Okay, then we will proceed to case 2018-014, which is in the name of Nathaniel Johnson.
Rick Wolf, City of Newberry Code Enforcement Officer, and in case CE 2018-014, the respondent is Nathaniel Johnson. Nathaniel Johnson's property is directly north of the property that was the Faith, Hope, and Charity Deliverance Center. They both were on 245th Street. The photographs that I will show presenting into evidence actually represent the violations as seen and were taken by me on the dates indicated on the photographs. On September 18th, 2018, I received a citizen complaint about a single-family mobile home with unlicensed vehicles and inoperable vehicles parked in the yard in the street, and with junk and debris including trash cans, auto parts, appliances, and sundry items at 440 Northwest 245th Street on tax parcel 019-17010-000. The property was inspected by me on September 18th and found to be within the corporate city limits of the city of Newberry and in violation of the following ordinances. Chapter 94, Section 94-124 for wrecked or non-operating vehicles on private property, zoning regulation violation for supplemental district regulations for parking and storage of certain vehicles, and minimum housing regulations for sanitation requirements at care of premises. The unlicensed and inoperable vehicles were parked in the yard, trash and cans and auto parts in the yard as well. This property is zoned single-family mobile home and is approximately 1,288 square feet in size. The property is homesteaded. The notice of violation number 2018-09009 was mailed by certified mail on October 23rd, as recorded in the tax collector's office to Nathaniel Johnson, owner of record. He received the certified mail and signed for it on October 24th, 2018, and the notice of hearing was achieved both by posting and by certified mail. It posted on November 27th and certified mail on November 28th. This photograph on the 18th shows some of the junk and debris in the yard and the vehicles on the property. Most of these with flat tires, no tags, inoperable. Trailer full of trash and appliances and trash in the yard, fencing materials. This was on October 2nd. Batteries and sundry auto part items. And there's the front yard with trash piled up in the front. One of the cars was removed at this point on November 6th. And on November 27th, we posted the property and also posted City Hall. This again, additional photographs on November 27th. The trailer full of the appliances had not been removed at that time. And we posted City Hall as well. This is my inspection on December the 18th, which was yesterday morning. The trailer was gone, all the vehicles were gone, the trash and debris cleaned up on the property. So in notice of violation, the respondents were given until November 20th to correct the violation, completing one or more of the following items: to remove the vehicles and clean up the cans, auto parts, junk, and debris. As a result of my inspections, it wasn't until December the 18th that they had come into compliance. Prior to that time, past the notice deadline, they had not. So at this time, we recommend a finding of in violation but now in compliance for the respondent, Nathaniel Johnson, for the violations that I had previously mentioned, and that corrective actions in the original notice of violation have now taken place. They're in compliance and no fine, and further that the city recover the cost of prosecution of $0. Your Honor, I would like to also state that Mr. Johnson had a medical appointment with his son today, and he was aware of our recommendation.
Okay.
That concludes staff's comments.
Okay, based on the testimony of our code enforcement officer, I will follow that recommendation that there was a violation. That violation has been cured effective December 18th of 2018 and will impose no fine and no cost. Okay.
Thank you.
Is that all of our cases?
That concludes our cases. Our next hearing will tentatively be scheduled for sometime in February,
Okay.
and I believe we'll probably have one or two non-compliance cases for that hearing.
Okay. Just a couple of bits of housekeeping. Number one, I would like to note for the clerk's benefit that all of the photographs that were presented would be admitted into evidence. And I want to ask about, I'm just looking at this, I want to ask about the, Mr. Wolf, about the affidavit of compliance. Maybe I don't want to ask about, I just want to pose this and then maybe let you talk with the city attorney. You've signed off on this affidavit. I'm using this last case as an example. You signed off on that, but there's not really a date of that affidavit. I do note that there's a reinspection date, and I'm assuming that's probably the effective date, but I think it probably would be good to have the date of the affidavit or a date right next to your signature there somewhere.
Good suggestion.
And I'm raising this next issue just because I anticipate it could be raised at some time in the future. In item 4, you state that the violation has been corrected and that code violation number, whatever the number is officially closed. So somebody could come to one of these hearings and say to me, you have no jurisdiction over this case anymore because it was closed. So I'm just pointing that out. I don't think it would really matter in terms of what you're asking for in these cases, other than because I'm not imposing any fine or imposing any cost. I am finding that there is a violation, so somebody might technically raise that as an issue and say to me, I can't rule on this case because you have closed it prior to us showing up for this hearing, if that makes sense. So,
we've approached this in a couple different ways when I worked for the county, and one is we've created a form that's called affidavit of compliance after hearing, and then the one that's the affidavit of compliance before hearing.
Right.
And but we can so note that.
Yeah, I think my thought would be, and again, I don't know, I'm not giving legal advice, I'm just pointing out the issue, and you can talk to your city attorney, but maybe the words there, maybe you just need to take out that it's actually been closed, so that doesn't get brought up in front of me, and I might have to say, yeah, you're right.
I may have been a little hasty trying to get these affidavits of compliance to you to show that they have
Right.
been corrected, but we could also wait till after the hearing to complete these.
Right.
So,
I think, and I guess my thought is you have the authority as code enforcement officer to close the case before it gets to this hearing. But if it does get to this hearing, then it's kind of like the jurisdiction then passes, that I would be the one closing the
Mhm.
case with whatever the order is. So I'm just pointing that out. So,
and typically, our department's policy has been that if someone corrects it prior to it being scheduled on the agenda,
right.
we would issue an affidavit of compliance with
right.
no hearing.
Mhm.
But once it's agended, I don't pull it off the agenda.
Mhm.
It has to go through your
Right.
process. So-
Okay.
And Your Honor, here are the four written documents of the violations for the cases.
Okay, so we'll admit those into the evidence of this hearing.
Your Honor, I do appreciate you pointing that out. That we will make a modification of that moving forward.
Right.
If that issue ever does come up, we can address that as a matter of law.
Right.
But hopefully, Alan can do that.
Yeah, it's not been brought up, so I don't think it affects anything that we've done, to this point, but somebody might.
That's a good point.
One other point I want to make is, and this relates to the hearing that we had on the reduction of the fine. There was discussion in some of that about a lien also, and I looked back at this before I came to the hearing to make sure that I thought that the magistrate had the power to make the reduction. And I think the magistrate does have the power to make the reduction of the fine. I don't think that fine turns into a lien until I say it does. And in that case, I reserved jurisdiction in that first order to convert it to a lien, possibly. But it was not actually converted to a lien at that time. And the other point of that is, once it's converted to a lien, I think I lose jurisdiction to do anything with that lien. So,
It's my understanding that you have the same authority as a code enforcement board would under
That's correct.
162.
right.
And that you can release an order or a lien. In this particular case, we knew that the auction was occurring, and so it was our intent probably to go forward and cite the new owner if they were reluctant to, but they right away worked with us and knew what they were getting into when they bought the property.
Yeah, so, but my point is, 16209 does say an enforcement board may reduce a fine imposed pursuant to this section. So, and I agree that whatever an enforcement board can do, a special magistrate can do. I think the statutes clearly say that. But then further down in 16209, it says a lien arising from a fine imposed pursuant to this section runs in favor of the local governing body, and the local governing body may execute a satisfaction or release of lien entered. So I think that tells me that once the lien is actually entered, then maybe it's a city commission that has to satisfy it or reduce it or release it.
And I believe the way my former employer approached this is the Board of County Commissioners delegated the Code Enforcement Board to make that decision
Okay,
in their adopted policies. So,
okay,
that's how it was handled, but
all right.
I certainly understand your point. We didn't file a lien in this case.
No,
We
well,
just
again,
recorded the order.
Again, I don't think you could have filed a lien because
We hadn't
because
heard
I
it.
didn't convert it to a lien.
We didn't have a
I
non-compliance
imposed a
hearing.
fine, but I didn't convert it to a lien.
Exactly.
And I think usually, my idea is that usually it wouldn't be converted into a lien until we could quantify a certain amount.
Mhm.
So, if you look at the order specifically in that particular case, I said that I imposed the fine of $50 a day from whatever date, but I reserved jurisdiction for the possibility of converting that to a lien. So I
Mhm.
agree, there was no lien in that case, so. so your city attorney may want to, if we ever convert it to a lien and somebody wants a reduction of that, I will want to hear that I have the power to do that. I guess is the way I'm saying that, so. All right,
Thank you for your comments.
sure. Is there any further business to come before us? Any public comment? Okay, we will stand adjourned.